So we're going to go live out to the Abby Zwerner trial in Newport News. Very brief background. I always do this. I apologize to anyone who has heard this many, many times before. Context for anyone who has not: Abby Zwerner, a teacher at Rich Neck Elementary School in Newport News, shot by a 6-year-old student in her classroom in 2023. She's now suing Newport News Public Schools for $40 million. This is the trial for that civil suit. Let's go live now out to Newport News.
JT's behavior during lunch, but not about a report of the gun. She had discussion with Amy Kovac in her classroom about the reports from the 2 little girls in her classroom. She had discussion with Amy Kovac in her classroom after Amy spent time with JT and did not search the backpack. She witnessed JT rummaging through the backpack. She witnessed JT put something in his pocket. And she observed JT at recess with hands in his pockets and R telling JT to keep his hands in his pockets. She had discussion with Jennifer West about that, the lead teacher with the walkie-talkie, and discussion with Amy Kovac at recess. But there are things she did not do. She did not follow up with the 2 little girls. She did not speak to JT, did not remove the backpack from the room, did not remove JT from the room, did not take JT down to administration, did not evacuate the classroom, did not call the guidance counselor, did not make use of the walkie-talkie, and did not call the parents of JT. Did not seek classroom coverage to personally discuss any of this with Dr. Ebony Parker. No visit, no call, no email. You'll get a jury instruction on contributory negligence. It is the failure to act as a reasonable person would have acted for her own safety under the circumstances of this case. Any negligence of Ms. Zwerner, which was the proximate cause of the accident, will bar her from recovering. Let's talk about other people involved that day. Jennifer West. You remember Ms. West, first grade teacher across the hall? She had the walkie. Classroom right across the hall from Ms. Zwerner's classroom, was on the playground during recess with other first grade classes. Learned about JT on the playground and the discussions about him. I was informed that he took something from his backpack. I can't speak for sure if I was told it was a weapon. That's what she said in court. She left the playground to deal with another student. Asked Ms. Zwerner to take her class back in the building. Remember, you're the judges of credibility. If you thought you were leaving a child on a playground with a gun, why would you say, why don't you shepherd your class and my class back in the building? Use your common sense. Ms. West encountered Dr. Parker in the hall. And so they've come in and said Dr. Parker was indifferent. Dr. Parker was dealing with another student, Ms. West's student, and she didn't say anything to her about JT. Use your common sense. There was discussion with R about what JT showed him on the playground. We've heard about that. And Ms. West said, R told me, he said that JT had a gun and he saw it in the bullet. And I said, well, what color? Trying to see if it was real or not. And he said it was bullet color. In trial, Ms. West had one version of that story. She was asked, Ms. West, you testified that when you arrived on the playground, you weren't told specifically whether or not JT had a gun. Answer, that's what my note I wrote down notes that night, and that's what my notes say. But in her deposition, she had to admit she said something different. Your testimony under oath at the deposition preceding the trial was that Ms. Zwerner had reported to you the child did in fact have a firearm. Well, that's what I said then, yes. You're the judges of the credibility of these witnesses. John Sims, music teacher, covering phones in the office. The most important thing he told you, Ms. West didn't call him. He called her about another student, and that's when she mentioned what R had said. Now let's get to Mr. Rawls. Remember Mr. Rawls? Who was he? He was the guidance counselor. He was a member of the threat assessment team. He was part of JT's student success plan. worked with him all the time, very familiar with JT, and he told you he had some learning and some behavioral issues. And JT had been taken to Dr. Parker's office on multiple occasions. And he, in fact, had been the one to take JT to the office 2 days prior when Ms. Zwerner asked him to. Mr. Ross told you about what happened on January 6th. He was working with Ms. West on her student that had eloped, that Dr. Parker was all involved in. So Dr. Parker, I think it's been said that she was sitting in there in her armchair. She wasn't sitting in her office on her armchair. She was working. She was dealing with other student needs. Ask yourself, does it make any sense that she would attend to that and blow off a gun in the school? Mr. Rawls said, I stumbled on some information about JT. No one called me. He's coming down the hall dealing with Miss West's student, and she tells him that R said something about ammunition or bullets. So Mr. Rawls spoke with R, and he did not interpret it to be a threat. It was a 6-year-old. 6-year-olds say things. Mr. Rawls, ever heard anything about a gun? No. You heard something about bullets? Yes. So at the time you did not feel the need to remove JT from Ms. Werner's classroom? No, I did not. Later that day, or a little while later, Mr. Rawls had a discussion with Dr. Parker about the other student and about ammunition or bullets, and the bag already had been checked. He learned that the book bag had been checked. And he discussed with Dr. Parker, checking the person. Dr. Parker looked at the clock and said, why don't we wait for his mother to arrive? And he said he understood because he was 6. And so think of the context that was going on at this point. He had been allowed, Ms. Kovac had investigated. She felt comfortable leaving the room. She felt comfortable not taking the backpack. She was not a young teacher. She was very experienced. She worked with this child every day. She knew this child. And she felt comfortable leaving that room. So that's a context. And then Ms. Werner didn't remove him from the room. And Mr. Ross told you he understood because it was a 6-year-old. And he didn't feel the need to go around Dr. Parker. He didn't feel the need to do that. It's a 6-year-old. Later in the day, Mr. Ross had gone back to his office. There was a lockdown, and he was coming down the hall. And he ran into some custodians. He didn't know there had been a shooting. And one of them said, they got him, and he said, got who? He told you he didn't have any idea who they were talking about. It was like, oh, it's JT. I knew it. I knew it. He didn't say that. He had no idea. And Mr. Ross told you that he went to his office and cried. You'll see that in the statement that HR had Dr. Parker write after, a couple days after. People hadn't lawyered up at that point. Maybe some of her language wasn't the best, but she told the story. She told that she cried too. They told the truth. No one saw this coming. Now let's talk about the experts in the case. Largely, their expert agrees with Dr. Klinger. Let's talk about it. Ann Shufflebarger. But let's first say, who is she? She's retired from the Virginia Beach Public Schools. She's never been an expert before. She was introduced to the case through her sister-in-law, one of Ms. Werner's attorneys. She agreed that this was a rare event. She agreed that the assistant principal is not solely responsible for school safety, that it's a team approach. You remember the Q&A? You agree that it's unfair to judge someone's conduct with 20/20 hindsight vision. I can see that. And you agree that Dr. Parker, in evaluating information regarding a 6-year-old having a loaded gun at school, something that had never happened to her, she didn't know the outcome of the day. Correct. She also agreed that school safety is a team approach. It's not just one person's job, and we'll get to that in a minute. because Dr. Klinger made that clear to you, and how that would be a terrible idea for it to be just one person's job. She agreed that the teacher in the classroom is the first line responder about student behavior. She agreed that assistant principals must rely on other staff members and teachers in determining whether reports are credible. She agreed that searching a student is a judgment call based on a lot of factors. She also agreed that it's preferred that parents are present during body searches of little students. She also agreed Dr. Parker didn't refuse to search JT. She wanted to wait until his mother got there because the level of concern was not high. Mr. Rawls had said it wasn't a credible threat. He told you that. She agreed that age is a factor in determining whether to body search a 6-year-old. Age and a lot of other things are a factor, she told you. Sex of a student's a factor. She agreed that you want to handle the student with dignity and that there are legal rights to their privacy concerns in body searching children. Most importantly, she told you she worked 40 years in the Virginia Beach public school system. And she told you that that never happened. No child, no elementary child ever brought a gun to school. Dr. Shuffleberger also agreed with me that Ms. Kovac and Ms. Zwerner were the first line responders to the reports about JT. She agreed that Ms. Kovac and Ms. Zwerner were in the classroom with JT after becoming aware of a potential weapon. She agreed that Ms. Kovac and Ms. Zwerner did not confiscate JT's backpack and that they did not remove JT from the classroom, and that Mr. Rawls had not determined there to be a credible threat when he spoke to Dr. Parker about JT. She agreed that other individuals did not stop what they were doing. She said she should have stopped what she was doing, Dr. Parker, but she agreed that no one else did. And as you recall, she didn't know the facts of the case. She told you that it was 2 teachers that came and talked to Dr. Parker about body searching JT, and on cross I had to get out the truth that it wasn't actually 2 teachers. She then acknowledged it. It was actually the guidance counselor on the threat assessment team who worked with the child every day. Surely, if he thought at that point there was a credible threat to search this child, he would have done something. You saw Mr. Rawls. Anybody doubt for a minute that he wouldn't take action if he felt like he needed to? Now let's move to the defense expert. You saw Amy Klinger, the defense expert. She has a Doctor of Education from the University of Toledo. She's a career educator and administrator. And now she works with school safety as a trainer and as a consultant. She founded the nonprofit called the Educator School Safety Network. She's a full tenured professor of educational administration. She's an instructor for FEMA and Homeland Security coursework. She has boots on the ground experience. She was a school principal from 1995 to 2008. She's researched, she's published, she's created training courses, and she's been an expert witness 25 times. Most of the time, she's against the school administrator. But she came here and she wasn't against the school administrator. She wasn't against Dr. Parker. She told you that Dr. Parker did not breach professional standards with respect to Ms. Zwerner on January 6, 2023. And she told you that Dr. Parker, it was her opinion that Dr. Parker was not indifferent to Ms. Zwerner on January 6, 2023. She detailed how she came up with that opinion. She reviewed body-worn camera footage from the Sheriff's Department. including an interview with Ms. Kovac right after the incident. She reviewed the school board video interviews with people that were involved in the incident. She reviewed forensic interviews, witness statements, incident reports. She reviewed the protocols, and you're going to get an instruction about protocols. Protocols, you'll see, does not set the standard of care. But she reviewed them, and she told you that Dr. Parker didn't violate any protocols. She reviewed all the depositions taken in the case, and she reviewed JT's school records and his court records involving his mother. She reviewed all of that before she was willing to come and sit on the witness stand, swear to tell the truth, and give you her opinions in this case. Dr. Klinger told you that school safety is everyone's responsibility. It's a collaborative endeavor. School safety concerns do not occur in a vacuum. Every person in the school organization has roles and responsibilities related to school safety, every single person. A school administrator cannot establish the credibility of a potential threat alone. They cannot be everywhere, and they cannot see everything. She told you that it's important that the school administrator get information and disclosures from the people who are closest to the event. Dr. Klinger told you that discipline is the initial responsibility of the teacher. That's a standard nationwide. It's also in the Rich Neck Elementary School staff handbook that you've seen, and I think it will go back to you, back to the jury room with you. Important to Dr. Klinger was the context of what else was going on and what Dr. Parker knew. That JT had been allowed to remain in the classroom and class instruction went on. The school day went on. The students went to recess. The first grade teacher discussed suspicious behavior on the playground, but they did not remove JT from the playground. Ms. Werner did not make any reports directly to Dr. Parker about a report that JT had a weapon. And she explained why that matters. She talked about first-line responders. We've mentioned it before. I want to mention again. And what she said is when an administrator is evaluating a threat, it's important to know what sort of actions are being taken so that what are the first-line people doing regarding the credibility and the appropriate action to take for a response. And what she told you is that what really matters is plausibility and foreseeability. And she said when you're discussing a 6-year-old, it's much different conversation than if you're discussing a middle school or a high school student. This is a 6-year-old. And she told you that when discussing a 6-year-old having access and ability to bring a weapon to school, clearly, we know at this point, it's unprecedented. That means it hadn't happened before. It was largely unthinkable and certainly unprecedented. Your job is to consider only what Dr. Parker knew at the time. And Dr. Klinger wasn't the only one that told you it was unforeseeable and unprecedented. Dr. Schuffelbarger. She agreed that in evaluating information regarding a 6-year-old having a loaded gun on January 6, 2023, it was something that had never happened, and that Dr. Parker would not have known the outcome of the day. Ms. Werner herself told you that when she saw the gun for the first time that day, when it was unfortunately pointed at her, that she was shocked because she didn't expect to see a real gun. And she had been in the classroom with this child and on the playground with this child. Amy Kovac said it too. Who would believe that a 6-year-old would bring a gun to school premeditated to shoot his teacher? Mr. Rawls said it. He talked about hindsight bias and feeling regret about what happened. But let's look at what Corporal Blythe said. He was one of the first responders, the sheriff. What did he say? We were quite taken aback. We didn't expect to see such a young suspect. It was unforeseeable, it was unthinkable, and it was unprecedented. I submit to you that Dr. Parker did not assume a duty of care to Ms. Zwerner. She did not breach a duty of care, and that she was not grossly negligent. And it stops there. And you don't even get to damages. However, I need to talk to you a little bit about damages, and I'm going to tell you why. As you may recall, I questioned some of Ms. Zwerner's witnesses about her damages. And there was a reason I did that. Ms. Zwerner has come to this court asking for $40 million from Dr. Parker. And she told you that she cannot even open a bag of potato chips. And her counsel, he repeated that today. As an officer of the court, and as my ethical duty to Dr. Parker, it's my job, unpleasant as it is, to come in and tell you there's a different side to that story. I'm an officer of the court. And so I questioned Ms. Zwerner and some of her witnesses about the fact that she has gone to cosmetology school, passed with flying colors, and is a licensed cosmetologist. And some of her witnesses have come in and said she only wanted to be a teacher, but I've shown you, if I'm admitted into evidence, are the texts that shows there's another side to that story too. And the other side to that story is that it was something, teaching was hard. And I'm not saying that to cast any blame on Ms. Zwerner, but to say she had thought about going to cosmetology school for years. So to come into the court and say, I only wanted to be a teacher, that's all I ever wanted, and now I can't, even though I don't think anyone testified she couldn't, I need $40 million. It's my job to tell you there's another side to that story. Ms. Zwerner and some of her family members have said that she can't leave her house. She's become reclusive, that she's withdrawn from the community. And again, I have to show you, when someone's asking $40 million from Dr. Parker, I have no choice but to say there's
Your Honor, the statement from Dr. Parker is an inappropriate statement of law.
Say that again?
The statement from Dr. Parker, I think, is contrary to the jury instruction.
I
They're
don't think-
there to assess the damage.
I don't think she said anything that Dr. Parker said.
No, I
I
did not.
didn't hear that.
He stated from Dr. Parker was counsel's argument.
All right, you overruled. You may proceed.
I showed you the social media posts that Ms. Zwerner produced in discovery. She produced them to us. Flip through them. She's reaching out to international celebrities to go to the concert 9 months after the shooting. Again, officer of the court, duty to my client, I have to tell you the other side. It's my job. And that's why we brought you Dr. Hagan. Dr. Hagan explained to you what a forensic evaluator does when determining whether someone has PTSD. Dr. Watson came, as eloquent as he was not Ms. Zwerner's treating healthcare provider. He was a retained expert, paid for by the plaintiff, to talk about her damages. But he did not look at her treatment records from before the shooting. He did not see that there had been diagnosis of PTSD before. And Ms. Zwerner herself, the last question exchange we had, she had to admit that she had not been truthful with Dr. Watson. I'm not minimizing what happened to Ms. Werner. I'm not doing that. I'm doing my job. I have to bring the truth and the whole story. It's the brutal honesty that Mr. Beniozen stood up when we selected this jury and told you he wanted. I have to do it. This case has been a long road for a lot of people. Mr. Beniozen glossed over the evidence in the case, and I want to thank you for listening to me as I went point by point what happened at Rich Nut Elementary School on January 6th. I went through the evidence, you heard the testimony, you weigh the credibility. These are the facts. And I would submit to you that when you go back and you consider the facts and the jury instructions that the court gave you, I would ask that you find that Dr. Parker did not assume a duty to Ms. Werner. She did not breach a duty to Ms. Werner, and she most certainly was not grossly negligent or indifferent to Ms. Werner. What happened at Rich Neck Elementary School on January 6, 2023 was a terrible tragedy on so many levels. So many levels. There's no one that does not think, that thinks otherwise. It was a tragedy that until that day was unprecedented, it was unthinkable, and it was unforeseeable. And I ask that you please not compound that tragedy by blaming Dr. Parker for it. Thank you.
Thank you. All right, you have a rebuttal closing, Mr. Beniozen?
Briefly, Your Honor. I get to go last. I'm going to be quick, I promise. Throughout the trial, every time somebody says something that I am sitting there and I just want to jump out of my chair and scream and say, that's not right. That's not how it happened. I write note cards. I go at home, I write note cards, and I keep track of them. And I have note cards for every time that somebody said something and I just wanted to jump out of my chair. And I'm not going to go through all of them. I'm going to go through some of them, and I'm going to go through them quickly so that you can get back into that deliberation room, okay? All right. Testing day. Remember this? Testing day. Today was testing day. Ladies and gentlemen, if Dr. Parker took as much care for those tests and exercised that care for the safety and security of the children and the teachers at this school, we wouldn't be here today. Express promises to protect. Remember, they put up this thing and said, well, you didn't say anything to her. You didn't. Dr. Parker didn't expressly say to you, I'm going to protect you. And that Abby didn't tell Dr. Parker herself. Well, what happened to this collaborative team approach? What happened to this collaborative team approach that we're talking about? Is it not enough that as a team they talked and said Ms. Kovac is going to go tell her? Which one do you want? Do you want it to be a team, or do you want everything coming from the same person? You can't have it both ways. And they all worked as a team, each and every one of them, except for Dr. Parker. And Amy Kovac sends a text message 2 days after the fact. Amy Kovac was on that witness stand, and if you pull it up, go ahead and read the text message. Pull up the text message, Amy Kovac on that witness stand. Did they ask Amy Kovac if, hey, doctor, did you know at that point in time that Dr. Parker was asked to search the boy at 1:40 p.m.? They asked him that? Did you know when you sent that text message that 2 other teachers came and asked her to search the person? Did they ask her that? Didn't want that answer. Did not want that answer. Because one person had all the puzzle pieces, and that person is Dr. Parker. And then you talk about going onto the playground. Going onto the playground. And what about what you did in the classroom? And why didn't you take them off the playground? And why didn't you search the backpack? The only reason they're able to point that finger of doubt at every single person in this school, except for Dr. Parker, is that Dr. Parker sat on her hands. At 12:21 p.m., if Dr. Parker was doing her job, she would have walked into that room, grabbed that book bag, and none of these questions would have ever been asked ever again. And because she didn't, because she sat on her hands, they now get to point the finger at every other person at this school and said, why didn't you pick up the ball that I dropped? Why didn't you pick up the ball that I dropped? And then they talk about what Mrs. Werner could have done sitting in that classroom. I want you to look at instruction 23 when you get in the back, okay? Instruction 23 says, a plaintiff has the right to assume, that a defendant will exercise ordinary care until she realizes, or in the exercise of ordinary care, should realize that the defendant is not going to do so. What does that mean? That means that when Ms. Zwerner talked to Ms. Kovac, and they went and told the principal, who they knew it was her job to deal with a gun on campus, she had the right to assume that somebody was actually going to come into her classroom and do something about it. For every minute, she had the right to assume, whether it was in the classroom, on the playground, in the hallway, whatever, they had the right to assume that somebody was going to do their job and take care of her. And then they get up and say, oh, the expert's lying because she mixed up a guidance counselor with a teacher. But it's not just the expert that's lying. They're all lying. They're all lying. Ms. Kovac didn't tell you the truth. Ms. West didn't tell you the truth. Mr. Rawls, I think, sounds like they told you the truth a little bit. Ms. Zwerner didn't tell you the truth. Everyone's lying. Everyone's lying. What does that tell you about common sense? They had days of evidence where you got to go home on Friday. Not a single person called. It was their turn. The only people they called as an expert were the people that they paid to come into this courtroom, and you're telling us that we're the problem for paying people? If anybody supported your position, march them onto that witness stand and tell us all the materials that Dr. Klinger reviewed, all the materials she reviewed, body camera, cops, witnesses, they help you? Put them on the witness stand. You didn't see a single one of them. You didn't see a single one of them. And if you didn't believe every word that was coming out of their mouth, and it's not exactly how it happened in your office, then get on the witness stand and tell us. There was all this conversation in jury voir dire about what it means to plead the Fifth Amendment. Ladies and gentlemen, somebody doesn't plead the Fifth Amendment unless they sit on that witness stand and say, I plead the Fifth. In a civil case, you don't have the right to remain silent until you actually exercise your right to remain silent. And not a single chance, they didn't want to take a single chance of her answering a single question. And if they didn't believe them...
Your Honor, I would check at the stage. Ask the sidebar, please.
No sidebar, overruled. You may
Then I
proceed.
would ask to voice my objection on the record, Your Honor.
You can after closing. Go ahead, Mr. Binion.
And then we talk about Taylor Swift. Taylor Swift. What I want you to do is, if you watch that, if you look at that clip, I want you to read the second sentence. And the second sentence says, I am the first grade teacher that was shot by a 6-year-old. What does that mean to somebody? That your identity, I don't walk around saying I'm my mother's child. I'm a first grade teacher. And Ms. Zwerner walks around life feeling like she has to tell everybody, this is me because this defines me. When you get into that jury room, the very last instruction is about life expectancy. What it says is that Ms. Zwerner has a life expectancy from today moving forward of 53 years. 53 years. Why is that instruction there for you? The instruction's there for you because when you're deciding what's full and what's fair, you're not just deciding tomorrow and what might happen the next day. You're not gassing up the plane to get to 45 or 55 years old. We don't get to come back here in 5, 10, 15 years and bring you all together and ask Ms. Zwerner, how are you doing? Are you still waking up at night? Do you still see that face? You have to make all of those decisions now. The other day, we took a lawyer break. Remember, the judge talked about lawyer breaks. A longer break than probably normal. And we were back in the room, and she was very nervous. And she was anxious. And we stood across the room from each other. And Miss Toscano said to her, and I looked at her and I said, whatever burdens you have, put them on me. Whatever burden you're carrying, whether it's in your mind, your soul, your body, put it on me and let me carry it. because that's what we do as lawyers. We accept to take this on through its ups and its downs, through the weight that it puts on our shoulders. And we accept that burden to be somebody's voice. And if I've talked more than I should, I'm sorry. If I haven't said the things that I should have said or how I should have said them, I'm sorry. I've done it the best that I can. The best that I can, and I love what I do. And if I could get in that room with you and scratch and claw and fight for her, do you doubt for a moment that I would? Do you doubt for a moment that she would or he would? I can't get in that room. This is the hardest part, because now my burden's off and I pass it to you. And I say, fight for her. Fight for her, please, if you think it's what's right. And return a verdict in her favor that we've asked for. Thank you.
All right, thank you. Mr. Hogan, the court notes that your objection was made contemporaneously with the statement that was made. However, I'm going to further instruct the jury, and then after I release them, but before sending any instructions or evidence back, I'll hear your motion.
Thank you, Judge.
Okay.
Just to make sure for purposes of the record that I'm able to articulate my objection and seek the specific relief that I'm requesting.
Yeah, you'll be able to, I promise.
Before it is submitted to the jury.
I understand. That's what I'm doing, okay? All right. Members of the jury, this is an important case to both the plaintiff and the defendant. In order to reach a verdict, each of you must agree on that verdict. Your verdict must be unanimous in writing and signed by your foreperson. The first thing that you should do when you go back to the jury room is to select a presiding juror. Who is your foreperson? The role of the foreperson is to see to it that the deliberations are conducted in an orderly and businesslike manner, that they are conducted only in the jury room when all members of the jury are present, and that each juror has the opportunity to fully and fairly express his or her views. In the jury room, you will have access to the exhibits that were entered into evidence. You will have the instructions of law that I have read to you, and you will have the verdict form as well that I have explained. You should discuss the case with your fellow jurors to reach an agreement. If you can do so, I suggest that you discuss the evidence and the law to your satisfaction before taking a vote. If you find differences of opinion, and if it would be helpful to do so, I also suggest that you identify those issues as to which there are differences, and that you discuss to see if your differences can be resolved. Any comments made by the attorneys or the court during any objections or arguments are not evidence and should not be considered as such. Each of you must decide the case for yourself, but you should do so only after you have considered all the evidence and the law, discuss the case fully with your other jurors, and listen to the views of your fellow jurors. Don't be afraid to change your opinion if the discussion persuades you that you should, but do not come to a decision simply because other jurors think it is right. Each of you must make your own conscientious decision. Do not change an honest belief about the weight and effect of the evidence simply to reach a verdict. Your verdict must be based solely on the evidence and on the laws I've instructed you. Nothing I have said or done is intended to suggest what your verdict should be. That is entirely up for you to decide. As I told you at the beginning of this trial, there are two of you are alternates. We did not pick those prior to or during this trial. We are going to pick them now, and they are going to be randomly chosen. My clerk has put all 9 of your names into a container that no one can see the names of, and a neutral and individual who I've selected to be the court reporter, who will not look at when he's picking, and he will pick 2 names out of those. After those names are picked, we will read you, they'll be given to me, and I'll tell you the numbers, which is why I asked you to bring your numbers with you now. You will then exit to the left with my bailiff, and you can retrieve anything from the jury room. So I have some good news for you, I think, for those of you who are alternates, that your term is over Friday. So you do not need to call back for any other potential jury service. However, since your term does extend through Friday, I ask that you do not discuss any of the jury service you have provided at any time during your month of service until after your term has expired. You are still under subpoena by the court. All right, court reporter.
Two? Pick one. All right. That's the one? Yes, sir. Okay.
All right, Madam Clerk, can you please read the numbers of the alternates and excuse them?
Juror number 5 and juror number 32.
All right. You are the alternates for this jury, and you are excused.
Please bring your book.
Wait for the deputy to come back. Has the plaintiff gathered all the exhibits that are going back from your side?
They're all with the clerk. Yes, sir.
Okay, and has the defense as well?
Yes, Your Honor.
Okay. All right, so how we are going to proceed once the deputy comes back is that I'm going to ask that you not begin your deliberations in the back. There is a couple other things we need to take care of. But then once the deputy brings you the jury instructions, the verdict form, and all the exhibits that have been entered into evidence, that is your cue to begin your deliberations. So don't begin until you receive those things in the back. Deputy, you may escort the jurors to the jury room. All right, you may be seated. Mr. Hogan, your motion.
Yes, Your Honor. To be clear, for purposes of the record, my understanding is after the matter, the case has not been submitted to the jury for deliberations, so this is a timely motion for mistrial, which I'm sure the court has anticipated. Judge, I move for a mistrial in this case. The standard is a manifest probability of prejudice. Two problems. In rebuttal, closing argument, plaintiff's counsel stood up here, pointed to my client directly, and asked the jury point blank to draw an adverse inference from the fact that she did not put on any additional evidence. This constitutes classic burden shifting. The jury instructions tell the jurors this is black letter law, that plaintiff's counsel, the plaintiff bears the burden by establishing by a preponderance standard each element that forms the basis of her claim. This is impermissible burden shifting. That error is compounded by the fact that Mr. Beniossen needlessly stood up here, again pointed directly at my client, and said that she didn't really invoke her Fifth Amendment privilege. She didn't invoke it whatsoever. She didn't put on any evidence. So it's fair game. You can draw an adverse inference against her because she elected not to testify. The problem with that, Judge, is in Virginia, I understand there's a distinction between the way the Fifth Amendment operates typically in the criminal context versus civil. And typically in the civil context, what has been addressed in the case law has been generally there's no blanket right to invoke your Fifth Amendment privilege. They have not addressed this in the context.
All All right, welcome back to the Live Impact News studio. The Abby Zwerner trial in the closing stretch here. It certainly seems that way, at least based on what we've been hearing. And we stayed with that for a long time. It is a massive local story with drawing national attention with a number of different surrounding layers that go into it that touch on aspects of society that have been under scrutiny throughout the last few years.